Welcome to our Curious Amalgam, the weekly podcast brought to you by the Antitrust Law section of the American Bar Association. Our Curious Amalgam explores the fascinating and increasingly overlapping world of competition, consumer protection, data protection, and privacy law. Each week, we bring you leading global experts on the most compelling issues of the day. Enjoy the show.
Welcome to our Curious Amalgam. I'm Barry Nigro, and the title of today's episode is What's Up with U.S. Merger Remedies? In this episode, we'll discuss the growing skepticism toward merger remedies by U.S. antitrust authorities. Among other things, we will discuss whether merger remedies remain a viable option, and if so, how parties should approach them, given the government's current skepticism. My co-host today is Jeny Maier. Jeny, would you like to introduce today's guest?
Hey, Barry, absolutely. It's my pleasure today to introduce our guest, Dan Ducore, who is retired from the FTC after more than 25 years as Assistant Director to the Bureau of Competition's Compliance Division. Dan has extensive experience overseeing and enforcing compliance with the FTC's merger settlements and divestitures. He's overseen litigation to enforce merger remedies, obtaining civil penalties, and court-ordered injunctive relief. Today's discussion is inspired by one of Dan's most recent articles called Negotiating Remedies, A Perspective from Various Agencies, which was published in Global Competition Review, and we will post a link to Dan's article in the show notes for all of you who are interested in learning more. Welcome to the show, Dan.
Thanks for having me.
Let's just get right to it. The Biden administration has grown increasingly reluctant to accept remedies for potentially anti-competitive mergers. And Assistant Attorney General Jonathan Kanter has publicly expressed his skepticism, and he stated that merger remedies, short of blocking a transaction, too often miss the mark. And DOJ under Kanter has preferred to challenge mergers rather than to negotiate remedy proposals. And consistent with this approach, DOJ has only entered into a handful of merger settlements since Kanter started as AAG, and one of which was the Assa Abloy settlement, which we'll discuss in a little bit, which came mid-trial. And while the FTC under Chair Khan has also been hesitant to accept remedies in merger matters, it has indeed agreed to a few more since the chair has been in her position, but it's still a small number of divestiture consent decrees. Just for you, Dan, why don't you just kick us off by elaborating on what are some of the specific factors that have contributed to the agency's skepticism towards remedies?
I think there's a few things, and I think if you read AAG Kanter's speeches and you read Holly Vedova's, a former FTC Bureau Competition Director, her early speeches under the new administration, they make the point that they don't believe that what we call negotiated remedies or settlements, including divestitures, are successful. I believe that may be a bit of an overstatement if you dig into the actual cases, but there are certainly a number of high-profile cases over the prior years that did not turn out the way the agencies had anticipated. And the phrase is once injured, twice shy, or whatever it is. And especially in the high-profile cases, Albertsons Safeway is the huge one lurking out there because it has implications for current matters. When the agency feels like it hasn't gotten what it's supposed to be getting, it's going to turn away from that. So I think there's a strong skepticism based on some high-profile failures and some other failures, as well as a view that it's really not what the agencies know how to do. The agencies are antitrust competition law enforcers. They are not business management experts. And when you get into the fine points of designing a divestiture, a lot of questions that can come up don't really go to what we think of as antitrust issues, but go to issues about what does a business need to succeed, which may be getting outside the wheelhouse, so to speak, of the agency, even as expert as they are. So you put all that together, and I think there's a new view that rather than get into all of that, the better outcome is just to block deals that are anti-competitive and get the courts to stop them and move on to the next case.
Well, there is some logic in that approach. Do you see any downsides in taking that kind of a strict approach to remedies?
Sure, there's a couple of risks, and they're for both sides. The risk to the agency is the obvious one that if they go to court and they seek an injunction and fail to block the deal, then the deal goes through. And it raises the question, might there have been a solution short of blocking the deal that would have eliminated or significantly eliminated the competitive issues and allowed the rest of the deal to go through? And if you try to block a deal and you fail, you've lost that opportunity. So there's no competitive solution to that problem, and it just is out there. That's the risk to the agencies. The risks to the parties, which I think we'll get to in a little bit, is that if you're litigating over the deal and there might have been a remedy, but you could never get to it, you've lost the opportunity to maybe achieve some benefits from the deal that you don't get when it's blocked completely. I know there's skepticism about that as an issue itself, whether any of these deals have benefits, but I think that's an argument that both sides need to be considering.
Dan, you've been talking a lot about the administration's skepticism toward remedies. The agencies, and while you were there at the FTC, have done a couple retrospectives where they've looked at remedies and whether they've been successful or not. Can you talk a little bit about those and share some thoughts?
Sure. In 1999, the Bureau of Competition published its first, what they called divestiture study, and they took a 5-year segment of samples and they looked at every divestiture in that period and asked the basic question, did it work? Meaning, did the buyer get into business to compete with the merged firm? And the results were somewhat mixed. In 2017, shortly before I left, the Bureau and the Bureau of Economics published a joint study that they called the Remedies study, which is a little broader, but again, looked at a 5-year group of all cases. And the results showed, and it's been put into practice, that when the agencies require a divestiture of the entirety of the business, not everything that was acquired, but whatever the competing overlap business is. And when the agencies have required that to be done, what they say upfront, meaning at the time of the merger, as opposed to giving the parties 6 months or a year to accomplish that, the results in that period of time were 100% successful. So that's what I mean when I say the statement that remedies fail may be a bit of an overstatement. Poorly designed remedies may certainly have a higher risk of failure than really solidly designed remedies. And I think the FTC, more so than justice, because the FTC has settled some cases, they're putting that into practice. I have not seen a settlement that doesn't require it to be done at the same time as a merger. And they're not entertaining arguments about how about if we divest this group of assets, isn't that enough? They're really looking at you need to divest the whole business so that you have whatever inputs are necessary, whatever supply contracts are necessary, marketing and sales relationships, all of that has to be part of what's divested, and you need to do it to somebody we can look at now before we let the merger go through. When they've done that, they've been fairly successful.
Dan, you talked about having to divest the whole business and not getting into any sort of discussion or negotiation about divesting something less. And I think that follows from the agency's view that any risk of failure should fall on the parties, not on consumers. In the Illumina decision recently, I think the Fifth Circuit seemed to suggest that there was a little more leeway on the remedy front in the sense that the remedy didn't need to account for every conceivable potential anti-competitive effect, that it should be considered in light of the substantial lessening of competition standard. And any thoughts on that?
Well, yeah, because this whole idea of putting in front of the judge the issue of what's an acceptable remedy is a fairly new one. In years past, the agencies would actually at times file motions in limine to preclude any discussion of a remedy, saying, look, it's the court's job to decide if we've made our prima facie case and then issue a preliminary injunction. Issues about what the solution might be are for later, and especially at the FTC, are for the administrative. But over the years, the courts have rejected that as an absolute and are now entertaining arguments about we have a solution. In Illumina, the technical legal issue was how much do you have to show that your remedy is enough to deny the injunction. And what the Court of Appeals said was essentially the remedy has to solve the problem, but it doesn't need to eliminate every possible lessening of competition, because the standard for a violation is not that it will lessen competition. It's that there's it's substantially likely to lessen competition. So there's room for argument about how much there needs to be a lessening of competition before there's a violation in the first place, and accordingly, how much you have to be able to show to eliminate that, to reduce that to some small enough level, and no court has said what's enough, that we will accept this risk to competition because it's not enough to make it significant. And it really gets into the weeds. I think the real point is it's got to be a meaningful solution. It doesn't have to be perfect any more than the government's case for a violation needs to be as an absolute. It needs to be a meaningful remedy that at the end of the day, the court can conclude this will not significantly, it's substantially, not likely, substantially lessen competition. You have to throw likelihood in there, and you have to throw substantial in there when you think about these.
So, Dan, we have seen over the course of the last few years the agencies taking this stricter approach and challenging more deals and having a mixed degree of success in litigation, in particular in cases where the parties litigate the fix, so to speak, as Barry was saying, like an Illumina Grail. From your perspective, do you think that these outcomes and litigations have changed or are likely to change the agency's approach? Do you think the agencies have overcorrected in terms of their desire to litigate? And do you think we'll perhaps see more engagement on the remedies front going forward?
That's a crystal ball question that's really hard to answer. I think the agencies are going to learn from their experience. It's always unfortunate when you lose a case, but you have to examine why you did. If you fail on the initial prima facie proofs, then the rest really isn't an issue. That's just a case that in hindsight should not have brought. When the parties offer enough that the court then says, if you're not going to take it, I'm not going to enjoin the deal, that's when the agencies really have to ask some tough questions. And I think they'll continue to do that. I don't think they are discouraged from challenging deals, including vertical deals. I wouldn't assume that a couple of losses in district court are going to turn the agencies around in their approach. I think they're going to look at each case and ask the same questions. If they're taking an aggressive attitude, then they're more willing to risk losses than prior administrations may have been. And I don't believe that is changing at the agencies.
From your perspective then, Dan, what do you think agencies can do to ensure that any remedies that they do enter or settlements that they enter into with parties can be effective?
Writing or drafting a solid remedy really requires asking all the tough questions about whether the package that's being divested is sufficient. And I think the agency have decided it needs to be complete without entertaining arguments about the buyer can get this input from somewhere else. No, that's going to have to be part of the deal. Number one. Number two, they're going to scrutinize the buyer to make sure the buyer's got, number one, the financial wherewithal to complete the deal and operate the business and expand as planned and desired. And number three, they're going to ask a lot of questions about the mechanics of getting it done. And the more there are steps that have to be taken, either in terms of getting regulatory approval for some kinds of products or qualifying a new supplier of an input, the more those questions come into it, the more risk the agency is going to see in the implementation of the remedy. I think they're going to tighten that up and make sure, number one, those questions are all answered, and number two, put people in place, they call them monitors, who are going to keep a daily eye on what's going on and report immediately if something starts to go off the rails, so that the agencies can get things back on track and not simply hear about it months later that this didn't work out as we planned. I think they're going to take a much tighter view of what needs to be done before they accept a remedy. And I think parties need to go in understanding that they're going to have to offer that if they want to try to negotiate a settlement.
So, Dan, what you just described sounds like the agencies, when they're in the remedy business, need to make a lot of business judgments. They impose a monitor, which sounds a bit regulatory in a broad sense. And isn't that what's driving the skepticism of the current administration with respect to remedies, that they think rather than become investment bankers, get involved in making those sorts of judgments and regulating the divestiture on a going forward basis, maybe we should just block the deal and avoid the risk of potential failure, the types of things that have come up and people have complained about with Live Nation Ticketmaster or the experience in Albertson Safeway.
Sure. And I think that's certainly where I think the agencies are, that if these proposed remedies pose more than an acceptable risk, and I think what's acceptable is the bar is being raised higher and higher. If they're too risky, we're just going to block the deal. The problem there, and I think the agencies have experienced it, is that it's not up to them to block the deal. It's up to them to ask a court to block the deal. And I believe part of the risk analysis should be, what's the risk that the court will disagree with us, either on the merits of the case or on arguments about the level of risk in the remedy. I think it's somewhat naive, frankly, to assume that they will just be able to block every deal if they don't like the remedy. And the experience has shown that they have sometimes lost in challenges to mergers. And it raises a question, might there have been a remedy there that could have been a solution and avoided the risk of litigation? But I have not heard the agencies acknowledge, let alone discuss, that whole issue about the risk of loss when they go into court. I just don't think it's on their list of issues.
Perhaps just briefly, this is a topic that I'm sure will, require, a deeper dive in a different context, but I wanted to make sure we got your point of view on the FTC's move to resuscitate or resurrect their use of prior approval provisions in their consent decrees. And for the benefit of the audience, these prior approval provisions require parties to obtain the agency's prior approval before proceeding with future deals in the relevant markets impacted by the merger at issue. And unlike the typical HSR process, whether the FTC grants approval or not is fully within the agency's discretion, and there are no real time limits on its decision-making process. What are your thoughts on the return of these kinds of prior approval obligations?
Before 1996, that was standard policy at the commission, and it wasn't something to be negotiated case by case. If there was a merger remedy, the merging parties were prohibited for 10 years from acquiring any competing assets in those markets, meaning the product and geographic markets. In 96, the agencies decided to move away from that and rely on Hart-Scott to get notice of future deals. I think there have been a number of examples where a party went and then acquired something in the market shortly after the merger remedy, and it wasn't reportable under Hart-Scott. And I think the agencies feel like, or the FTC feels like, if they've done all the work to examine this market and define the product and geographic markets, that should be sufficient for at least a period of time, that they don't have to do that analysis all over again. If the party wants to do a deal, they're going to have to come back and make the case why this time the deal in that market should be approved. There's a few nuances there. One is that they are requiring buyers for a 3-year period in general to get approval before they sell what they bought to anybody. In other words, if you buy these assets in a divestiture, you can't turn around and exit within a year or two if you don't think it's working out. That seems like a tax on the buyer and can make finding an acceptable buyer harder. But I think another way to look at it is that it's somewhat of a reality check that to the parties, if you're going to bring somebody to the agency as a divestiture buyer, you need to bring somebody who's committed to doing this, not somebody who's thinking, I can invest in this, I'm going to buy it at a fairly low price, and if it doesn't work out, I can sell out. I don't think you're going to see buyers come to the commission and ask to be allowed to sell out unless you have something really turned sour in a divestiture. But it's the FTC's way of saying, once we've looked at a market and decided what the market is, all that work doesn't need to be done over again for a short period of time. Interesting is that DOJ has never had that policy. They have routinely had a policy that their orders prohibit buying back what you divested, but they left it at that. So the two agencies take a different view of this. What that means going forward, I don't know, but I don't think it's something parties should think they can negotiate at the FTC. It's the new policy. It's a expansion of a prior policy, but it's essentially the prior policy. And again, it's not a case-by-case negotiation. It's just going to be part of essentially the boilerplate of any remedy.
So given all that we've discussed and where we are in antitrust enforcement these days, do you think deals that require remedies are dead on arrival?
I don't think so. I think there's going to be a heightened skepticism like we discussed. I think parties should not do what some parties in the past have done, although not so much recently, which is come in with a really thin offer and expect to sit down with the staff over the next coming months and negotiate how much more they have to add, before the staff says that's good enough. I think if they come in with an attitude like that, they're going to get rebuffed. I think what parties need to consider is that, number one, if they want to propose a remedy, it needs to be rock solid. It needs to be something that they can argue, first, substantively, this solves the problem. And it eliminates, we've identified all these risks and we've eliminated them in either the buyer or the package or how we've negotiated this. And number two, I think make the argument that we think this is a good position for us if we end up in litigation. And then people are going to have to put on their eye shades and examine this and do some risk analysis and think about it. But I think remedies are not dead on arrival. I think cheap remedies aren't going to be entertained. And frankly, they weren't really entertained so much in the past.
So before we end, Jeny has a couple of questions for you, Dan, to allow us to get to know you a little better. Jeny?
Oh boy. Okay.
Thank you, Barry. And thank you, Dan, for a really engaging conversation and sharing your wisdom from the last 25 years at the FTC. I really learned a lot from our discussion today. And now I'd like to learn a little bit more about you as a person. So why don't you tell us something that we wouldn't know if we only knew you professionally?
What people may not know about me is I have a deep love of classical music. And I played piano, took lessons as a kid. I don't practice as much as I should, especially if you ask my wife. She threatens to sell the piano if I don't get back to practicing. But it's really something that I've done virtually my entire life and not about to give it up. Not part of my professional life, but it's part of who I am.
Dan, our last question is one that we at our Curious Amalgam do with all of our guests. It is called the Curious Hat. And in this part of the program, we will pull a question out of my imaginary hat to ask you.
And now it's time for the Curious Hat.
Today's question is, when you were a child, what did you want to be when you grew up?
When I was a child, I wanted to be a lawyer. Believe it or not, my grandfather had been a lawyer. He had retired before I was born. But it was always something that I was thinking about, maybe because I like to argue. One of my sons has taken up that habit, but although he's not a lawyer. But I really always wanted to be a lawyer, not particularly ending up where I ended up. I don't think most lawyers could say as a child that's where they were intending to be. But this is what I wanted to do. And I went right from college to law school to pursue it.
A great conversation today, and we're grateful for everything that you've shared with us.
I'm happy to share my limited wisdom.
Thank you for listening to this week's episode of our Curious Amalgam, a competition, consumer protection, data protection, and privacy law podcast. It is produced and shared around the globe by ABA's Antitrust Law Section. The opinions expressed by the participants in this podcast are their own and do not necessarily represent their employer or other organizations. If you like what you heard or would like to become a member of the American Bar Association, please check out what the Antitrust section has to offer at ambar.org/antitrust. You can learn more about our podcast at ourcuriousamalgam.com. If you have comments, suggestions, or podcast ideas, please reach out to us at podcast@ourcuriousamalgam.com. Until next time, thank you for listening.